We'll get started. I now welcome Prosecute, Don't Perpetrate to give evidence. Ms Hutchinson, for the record, could you please state your full name and the capacity in which you appear before the committee?
My name is Susan Hutchinson. I am the campaign architect of Prosecute, Don't Perpetrate.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Over to you, Ms Hutchinson, for an opening statement.
Thank you. I want to begin my opening remarks today with a few words about a quote taken from the Allegiance to Australia Act. It states that its purpose was to enact a common bond involving reciprocal rights and obligations. And as far as I can tell, that notion of reciprocal rights and obligations harks back as far back as the 17th century and John Locke's liberal ideas about the social contract. So, as even that revered English philosopher believed that citizens only gave up their individual rights in order for the government to enact law and order. Yes, Australian citizens have an obligation to behave within the law, but in preparing this bill, I believe that insufficient consideration has been given for the government's obligations to enforce our own criminal laws when Australian citizens have travelled to Syria and Iraq and fought with extremist groups like ISIS. The specific laws I speak of are those found in Chapter 8 of the Commonwealth Criminal Code, Offences Against Humanity. Division 268 in that chapter includes genocide, crimes against humanity and war crimes. The penalty for these crimes is life imprisonment. Division 270 in that chapter includes slavery and sexual servitude, and the penalties for those range from 15 to 25 years imprisonment. Wartime rape is too often something horrible that occurs somewhere else in another country by people from another country against people from another country. But we have this unique moment in time to stand up and help end impunity for conflict-related sexual violence. ISIS and its members perpetrated sexual violence as war crimes, crimes against humanity and genocide. In Australia, we have the laws criminalising these acts, and we know that over 200 of our own citizens travelled there, many of whom broke these laws. I've worked with members from all parties in both houses of this Parliament who passed motions recognising these crimes and calling for the investigation and prosecution of Australians who perpetrated these offences. Myriad ministers have said we will investigate and prosecute, but revoking the citizenship of foreign fighters poses a significant barrier to criminal prosecution. You've heard from others about effectiveness, about revoking of citizenship, and I could testify to this issue. But I hope to answer questions today about how citizenship revocation provisions contradict our international obligations to investigate and prosecute foreign fighters who perpetrated war crimes and crimes against humanity, as well as genocide through the use of sexual violence. This is fundamental to justice for Yazidis and other persecuted minorities, to the rules-based global order that Australia is supposed to support, to gender justice and to international peace and security. It meets our obligations under the Rome Statute of the International Criminal Court, to the Genocide Convention, and a whole range of resolutions passed by the Security Council. It would even align with our own forthcoming whole-of-government National Action Plan on Women, Peace and Security. But it would also keep violent offenders in prison. So many others have been concerned only about prosecuting those people for terrorism offences, when in fact there is a whole other chapter of the Criminal Code open to law enforcement that is so far not being used. And that's all I have to say to begin with. Thank you very much.
Thank you. So Ms Hutchinson, just to be very clear, you're opposed to the bill in its present form?
I am opposed to the bill in its present form. I think it has some advantages, and I am expecting that that it will probably pass. I have some specific amendments that I would like to see to it. One in particular, particularly to 36E, and I can talk about the details. I see the world in grey, so I understand that.
Well, I appreciate your starting position. Noting that we do want to improve it, we'd be very interested in your thoughts. So if if you could go into that detail, that would be great. Thank
Yeah, certainly. So, it's great to see the repeal of the operation of law components of the current legislation, which was entirely unsatisfactory. But I guess the primary, to start with a constructive point, the key problem is, I think for a range of reasons it's an ineffective tool to revoke citizenship, but if it is going to remain a tool in the government's toolkit for fighting terrorism, then I think in 36E it's important that if the ministerial decision-making model is going to remain extant, then we would insert in paragraph 2, we would insert a consideration for the minister similar to the one which is around prosecution for terrorism offences. Then we would be merely inserting a consideration which is around the consideration for prosecution of offences under Chapter 8 of the Criminal Code.
Can I ask a question on that? Which is, I'm just... Sorry, I don't want to...
Yeah.
I'm just trying to clarify, how do you mean that would practically work? So my understanding from what you're saying is you don't want people to lose their citizenship because you want them to be investigated and to be held accountable for their conduct. So you then put into the provision around 36E that had to be a consideration as part of whether the ministerial direction was to...
Yes.
Ministerial decision, I should say correctly.
Yep.
So are you saying then that the minister would say that someone should not lose their citizenship because it prohibits or limits the capacity to investigate? Or are you saying that it's something that, or to be held accountable for their conduct? Or is it saying that we might do it in the future but we're just going to wait? Or...
So it doesn't necessarily prohibit the capacity to investigate. It does. So it does actually. So in terms of the, so at the moment there are a range of government agencies who have access to information about what these individuals might be doing overseas. The extent to which that information would be admissible in court, i.e. Could be used for the purposes of criminal accountability, will vary depending on their citizenship status. But that can be remedied if in a slightly separate issue to the purposes of this inquiry, but needs to be remedied through mechanisms within government. Government agencies need to sort of go through some coordination to be able to come up with a process so that they work together to achieve this objective. But what the citizenship revocation, the main barrier that it poses is around the prosecution. As you discussed this morning, obviously these prosecutions can't be done in absentia, and so that's the key barrier. But it also is a key problem with regards to extradition. So Neil Prakash is an excellent example. We had an arrest warrant was promulgated for Neil Prakash, but it was primarily for terrorism-related offences. At the very least, he could have also been charged with inciting genocide under Australia's existing legislation. That was not included in his arrest warrant, and that, but that would arguably is actually a responsibility of ours under the Genocide Convention.
I'm not contesting that. I'm just trying to get to exactly how you think that what you're asking for would practically work.
Yeah.
Which is that there's an additional inclusion under 36.
So I propose that it would be a new subparagraph G in 36E2.
Yeah. And so as a consequence of insertion, that would help to shape the decision of the minister.
Yeah.
And as a consequence, it would lead to a consideration which would lead to a situation where they chose not to take an action on the basis of the capacity for them to be able to essentially prosecute.
Yes. So let's say, for example, that someone was in reality actually just a cook or something, and that they weren't actually leading ISIS troops or beheading people or holding people in sexual servitude, and that they hadn't been promoting the killing of Yazidis or holding people in sexual servitude on Twitter.
So in the case of them being in a declared area, you mean?
Yeah. Then we didn't need to worry about, then they hadn't been, then it was apparent that they hadn't been perpetrating war crimes, crimes against humanity, or genocide, then that would not need to be a consideration that the minister would take.
But if it was included then and it came up as part of a discussion around the revocation of citizenship,
yes,
because you want to, you're essentially your argument, and I'm not trying to criticise, I'm just trying to clarity,
yeah,
is because you want to hold somebody accountable and because of the change in the circumstances depending on whether they've deemed to have or been considered to have potentially committed a war crime, that the scenarios where you would not want people to lose their citizenship to maximise our capacity to hold them to account for their conduct?
No, so now I am confused. Sorry.
So that's why I'm confused. That's why I'm trying to get to the bottom of it.
Okay, so if it would seem that they have perpetrated these, that they have potentially perpetrated these crimes, then we would not want their citizenship revoked because we would want to investigate and prosecute them for those offences.
And so the practical application is, and not to make light of it, if you say that you meet that threshold, then when most people would say, if you meet that threshold, we definitely don't want you back, your argument is we definitely want you back.
You are a terrible human being, but Australia, as an upright global citizen, is going to meet its obligations under the Rome Statute of the International Criminal Court.
For the senator who has just walked in, she was. I do not believe the witness was accusing me of being a terrible human being. Sorry, can we just because there seems to be this ambiguity, can we clarify that is not the spirit of intent? On a matter of extreme seriousness.
And it will apply our own criminal code. So that criminal code, what is in our law, what's in that, those divisions, 268 and 270, apply globally. Yeah. So it doesn't matter, under our criminal code, it doesn't matter where those acts occurred.
Yep. Can you at least appreciate that from the public's perspective, and I imagine from some people sitting around this table, while there's obviously a very high degree of sympathy that we want to hold everybody who commits war crimes to account.
Yeah, but we're not talking about holding everyone to account.
No, I understand. But those people who are suspected of committing war crimes who are at least dual Australian citizens, that if we amplify, if we start to say that that's the basis on which we don't want to revoke their citizenship, some people would find that quite extraordinary.
But the reality is that these people are already Australians, and they were Australians when they committed these acts. The whole point
of legislation say that they've essentially chosen to revoke that.
Sorry, could you say that again?
The whole point of the legislation is essentially to say that they forego that citizenship because they've lost their loyalty.
That is correct, and you're talking about applying this retrospectively. And as we've already heard, that there's a whole range of issues around applying retrospective legislation around that. And that is something that I won't let go of. I think that retrospective legislation around that is deeply problematic. We remain, if you want to talk about what Australian values are, I believe that Australian values are around global citizenry, around support for the rule of law, around good governance. And I believe what I'm proposing, I believe, supports those values. Please don't think
I'm challenging that. I mean, I think your point fundamentally, if I understand it correctly, is it's actually one of responsibility.
Yeah.
And as a nation. And so
absolutely.
My question is not about Australian values and getting into a murky discussion about what that means. It's the public perception, which is, so if you go into a declared area and you end up losing your citizenship as a consequence of your behaviour, but if you do that and then you get escalated to the level of war crimes, and we definitely want you back, and there's a certain disconnect. Low level is fine, You can revoke somebody's citizenship, but when you take it and escalate it to extreme examples, then it actually has the reverse response.
Well, not necessarily. So if you look at what is happening in Syria and what may potentially... So we thought that... I mean, if you look at the Insulam's report about the changing threat environment since the 2015 legislation passed, and what the threat environment is now, in the last 2 weeks in that context, the hesitation about responding to families of foreign fighters in Syria now means that we're facing a much more volatile environment where women and children who could have potentially been de-radicalised under supervision of Australia's incredibly competent national security authorities are in fact now going to be freed by are in a situation where there is a renewed war in Syria, in northeastern Syria, where the Kurds are unable to maintain control of prisons holding ISIS fighters, where we could have been holding up our obligations to maintain our own laws, to implement our own laws, and detain people who had broken our own domestic criminal code.
Can I ask a related question? Is that okay?
Yeah, if we could.
Go nuts.
Thanks. I appreciate the fact that you want to arrest and punish people who have done these really terrible things.
Yeah.
It's I'm with you. Like what has been done to the Yazidi women and the notion of sexual servitude is abhorrent. But noting how hard it is to gather the evidence that's needed to prove a case of sexual violence, even domestically, it can be really difficult stuff to prove, even at the best of times. And here we've got the complexity of gathering evidence from conflict zones, people being displaced, witnesses hard to track down, potentially some evidence gathered by, say, defence or intelligence agencies not being admissible. All of those challenges to getting a prosecution over the line, we face a very real risk that you could bring somebody back for prosecution for these types of sexual crimes, but not be able to hold them accountable, and in doing so potentially expose the Australian community to these really bad people.
Yes.
How do you reconcile what I think is a real demand in the Australian community to not be exposed to this risk with the difficulties of getting a prosecution of this kind over the line?
I think there's several elements to the answer to that question. The first is my understanding. First of all, I'm not a lawyer, but my understanding is that the evidential requirements are different than what they would be for example, for a standard rape case. We're talking about war crimes. The sexual violence as genocide is different than the crime of rape, and that's why it's a different crime, and that's why it's a different crime under the criminal criminal code. And what is quite peculiar about the way that foreign fighters and the way that ISIS has been behaving is that although a bunch of the evidence has been gathered by intelligence agencies, a lot of it has actually been happening on social media. I mean, someone was talking about a Twitter video of holding up of a severed head.
But even those are really hard to get into evidence. Some stuff on social media is really, really hard to prove connection to a person.
In terms of questions of, so if we go back to Neil Prakash and questions around inciting of genocide, some of the evidence, I believe, is in the public domain. And Parallel to the questions that I am hoping to bring to the committee today with regards to the revocation of citizenship, there is a body of work that I'm doing with a range of departments to try and get them to work together and adjust the way that they do business so that these questions of the way they work together, for example, and I included the draft business process map. I have, for example, a multi-agency workshop that I'm trying to get off the ground so that all of those relevant departments can work better together, so that there's a streamlined business, so that they can agree on a business process, so that they can share information in a manner that would support AFP investigations towards successful prosecution by the Commonwealth Directorate of Prosecutions. But I'm slightly concerned that that question may not necessarily be directly related to the question of to the core question of citizenship revocation. I believe that those bodies of work need to be done in parallel, that I can assure you that body of work is being done, that it's a body of work that needs to be done with a whole range of government departments, and it is being done, it is being made with the Department of Home Affairs, with Department of Defence and agencies thereunder, with the Department of Foreign Affairs and Trade, with intelligence agencies, yes, with non-government agencies, I was meeting with Defence Minister's Office 2 days ago. So this body of work is being undertaken.
We'll go to Senator Keneally and then we're going to wrap up, given the interest of time. Thank you.
Thank you, Chair. Really, this is more an observation than a question, but I think it might be useful to make, and I hope it is, and I do share your concerns as well as those expressed by Senator Stoker and Senator Wilson. We all would like to see bad people prosecuted. I would just draw your attention, it might be useful, I don't know if you've had a chance to see the ASIO submission, but ASIO actually deals with some of the issues you're raising because it makes the observation that the change that this bill is making to a ministerial decision-making model will allow ASIO to actually contribute to the decision and to advise that there are times in which it would be preferable not to strip citizenship, even though the conduct might meet the legislative requirement, because ASIO is of a view that it was in the best interest of national security to prosecute or to return the person to Australia, perhaps as an information source.
Yes.
So I would just refer you to that ASIO submission because it actually does recognise this bill allows for that decision-making to occur.
Yes, and I think that that's one of the examples of where this would still provide an improvement on the current model that exists.
Yes. Thank you.
Thank you, Senator Keneally. Good point. On that note, Ms Hutchinson, thank you very much for your time, for your evidence today and for your submission. And if there's anything additional, please get it to the Secretariat by Wednesday of next week. And we'll give you a transcript as per usual. We'll break for 2 minutes and then we'll hear from the Australian Centre for International Justice. Thank you.